12. The burden of proof and its cousins. 12.1. The burden of proof. Law navigates through a fog of uncertainty. In attempting to figure out what happened in the past, the legal system must deal with faulty recollections, lost documents, missing witnesses, inattentive jurors, and countless other impediments to knowing with very much confidence what actually took place months or years earlier. And even in trying to assess what law should apply to the facts so imperfectly perceived, lawyers and judges face a world of conflicting precedents, vague statutes, substantive disagreement, and a host of additional obstacles to being able to determine just what it is that the law requires. Not only does law do its work under conditions of uncertainty, but the legal system is also a complex one in which the separation of powers, in the non-technical, or at least non-constitutional sense of that term, is a dominant consideration. Appellate courts must take account of the tasks assigned to trial judges and trial juries. Federal courts are constitutionally required to be cognizant of the proper domains of state courts and vice versa, and courts engaged in judicial review of legislative or administrative action need to recognize the distinct responsibilities of legislatures and the specialized expertise of agencies. The question before a judge is rarely simply the question of what is right, but is almost always imbued with the issue of whose job it is to determine what is right. Jurisdiction may be an important component of the law of civil procedure, but it is even more central to the very structure and idea of law itself. For law is characterized by its concern not only for what is decided, but for whose job it is to decide it. Under such conditions of uncertainty and divided responsibilities, the burden of proof and its companion concepts of deference and presumption play a huge role. These concepts tell us just how sure the legal system needs to be in order to reach a particular conclusion, and indirectly tell the system what is to happen in the event that it is not sufficiently sure. And by specifying how confident the law must be in order to produce a particular legal outcome, the burden of proof especially reflects deeper substantive and not just procedural values that vary depending on the consequences of that outcome. The most familiar operation of the burden of proof is in criminal cases, where we encounter the well-known requirement that the prosecution must prove its case beyond a reasonable doubt. But what does this mean, and what values does it reflect? In order to address these questions, and also for purposes of simplicity and clarity, let us assign a rough numerical probability to the burden of proof. We can thus start with the premise, say, that the prosecution must prove its case such that the jury, to convict, must be 95% certain of the defendant's guilt. This percentage is in some sense arbitrary, or at the very least a rough estimate, but it captures the basic idea that the beyond a reasonable doubt standard requires that the jury or judge have a very high degree of confidence in the defendant's guilt in order to convict. If they are not 95% sure, then they must render a verdict of not guilty. An important feature of such a high burden of proof is that if taken seriously, and there is scant reason to believe that it is not in most criminal cases, the 95% beyond a reasonable doubt standard can be predicted systematically to let a large number of guilty people go unpunished. Suppose we have 10 defendants, and suppose further that each of them is 90%, but only 90% likely to have committed a crime. If the jury is doing its job properly, then all 10 defendants will go free, because in none of these cases will the prosecution have met the requisite burden of proof of 95% confidence in the defendant's guilt. But because each of the 10 defendants is 90% likely actually to have committed the crime with which he has been charged, we can expect that 9 of those 10 acquitted defendants will actually be guilty of that for which they are on trial, in spite of which they are now going free. In letting so many of the guilty go free, the proof beyond a reasonable doubt standard may seem like a bad idea. And of course it certainly does seem so to legions of politicians who claim that the legal system coddles criminals and lets far too many of them escape their just deserts. But William Blackstone has given us the canonical justification for the law's approach. The law holds that it is better that 10 guilty persons escape, he wrote in 1769, than that one innocent suffer. What Blackstone understood was that if the legal system employed a lower burden of proof in criminal cases, say 60%, then we could expect that for every 10 defendants for whom the probability of guilt was exactly 60% and no more, all 10 would go to prison. But only 6 of them would be guilty. No guilty people would go free, but 4 innocents would be punished. And that, for Blackstone and the legal system he celebrated, was just too much. It is unfortunate when guilty people go free, Blackstone thought then, and we still think now. But it is far worse when innocent people are condemned. Consequently, the legal system calibrates the burden of proof in such a way that the law can serve the social interest in convicting the guilty, while keeping the number of innocents that it punishes very low. Blackstone's solution, our solution to the problem of uncertainty, is far from perfect. If we really wanted never, ever to convict the innocent, we would set the burden of proof astronomically high, absolute certainty, or 99.99% determined by 3 consecutive juries, or something of that sort, and we would have solved most of the problem of convicting the innocent. We would have done so, however, at the cost of convicting far too few of the guilty. The standard that common law legal systems have chosen is a balance, but a balance heavily weighted in favor of the social judgment that convicting the innocent is a great deal worse than freeing the guilty, but also that avoiding convicting the innocent is not the only social value there is. Now let us compare to the criminal standard the standard that is typically used in civil cases. Here the plaintiff will prevail simply if she proves her case by a preponderance of the evidence. The British call this the balance of probabilities. If the plaintiff proves her case by a bare preponderance 50%, say she will win. But if she falls below that, she will not. This is a very different standard from that used in criminal cases, and that is because the values at stake are very different. Yes, it is regrettable when a defendant who is not actually at fault, say, is held liable in a tort action and has to pay damages. But in the eyes of the law, this is no more regrettable than someone who is injured through the fault of another, not being able to recover because the defendant has been mistakenly found not to be liable. Unlike in the criminal case, where we deem the mistake of imprisoning the innocent far worse than the mistake of freeing the guilty, in the civil context, we consider the mistake of a wrongly uncompensated plaintiff to be no less serious than that of a defendant wrongfully held liable. The two errors being equal, the burden of proof selected reflects this underlying equality of values. Although proof beyond a reasonable doubt and proof by a preponderance of the evidence are the best known and most widely used of law's burdens of proof, there are in fact many others. People may not be committed to mental institutions, for example, unless they have been proved by clear and convincing evidence to be dangerous to themselves or others. And it is generally accepted that this standard is somewhat higher than proof by a preponderance of the evidence, yet somewhat lower than proof beyond a reasonable doubt. The police may obtain a search warrant only if they can establish probable cause, the exact words used in the Fourth Amendment, to believe that the search will yield evidence of the crime they are investigating. And although it may be even harder to translate this standard into a number, it is well understood that this places a higher burden of proof on the police than the reasonable suspicion standard applicable when the police would stop and question a person but not seek to search his residence. Although the burden of proof is most visible with respect to the final determination of the outcome of a civil or criminal case, it is even more prevalent when used in conjunction with the various decisions that have to be made prior to final judgment, or when the burden is assigned to one party or another for various elements of a case. For the numerous legal and factual questions that are heard by judges leading up to the trial itself, for the procedural and evidentiary issues that arise during a trial, and for numerous different substantive issues, one party or another will have what is called the burden of persuasion. In criminal cases, for example, the defendant will have the burden of persuasion on defenses, such as insanity, alibi, and self-defense. And in tort actions for trespass or battery, a defendant who claims consent must persuade the trier of fact that such consent existed, as opposed to the plaintiff having to show that there was no consent. And on most procedural issues arising at or before a trial, it will be the moving party who bears the burden of persuasion. The burden of persuasion needs to be distinguished from the burden of production, sometimes called the burden of going forward with the evidence. Largely because one party or another is more likely to have the relevant information, the law will often assign to a particular party the burden of producing sufficient facts to put some matter at issue. And this is what is called the burden of production. Sometimes the party with the burden of production will also have the burden of persuasion, but often the two will be distinct. In contract cases, to enforce a contract, for example, it is common for the defendant to have the burden of coming forward with sufficient evidence to put into issue the possibility of mutual mistake, or impossibility, or release. But once the defendant has met its burden of production, the burden of persuasion still rests with a contract enforcing plaintiff to show the lack of release, or the lack of mutual mistake, or the lack of impossibility. Whether it is the burden of proof for the case as a whole, or the burden of persuasion on a particular issue, or the burden of production of evidence, it is important to bear in mind an important theme. These devices are all called burdens for a reason. From the point of view of an advocate, these burdens, like most other burdens, are almost by definition something that you do not want to have. The burden of proof is, for entire cases, or for components, parts of them, something a lawyer wishes her opponent to have. And often much of legal argument consists of attempting to persuade a judge or jury that your opponent has the burden of proof. It is an exaggeration to say that once you have saddled your opponent with the burden of proof on some issue, your job as an advocate is done. As we know in the criminal law, even high burdens of proof are met with great frequency. Still, the advocate who can persuade the decision maker that the other side has the burden of proof has gone a long way toward success, and as a result, arguments about the burden of proof are as frequent in legal argument as arguments about the law and the facts themselves. 12. 2. Presumptions. As we have just seen, allocating the burdens of proof, persuasion, and production is one way in which the law deals with decision-making under factual uncertainty. But it is not the only way. Often the law uses presumptions, which are the starting point from which factual inquiry takes off, and which specify what facts will be taken to be true if the party with the burden of proof does not satisfy the burden of proof, and thus overcome the presumption. Presumptions also specify what additional facts are taken to have been proved when one of the parties proves some particular fact. In some respects, a presumption is prior to but closely related to the burden of proof, because it is a presumption that typically establishes who has the burden of proof, independent of just how much that party needs to demonstrate in order to satisfy it. And it is the presumption that specifies what is to happen when the party with the burden of proof on some issue does not meet it. When we say that a defendant in a criminal case is presumed innocent, for example, we are also saying that the prosecution has the burden of proof, with the failure to satisfy it resulting in the defendant's acquittal. Similarly, when it is held that a will is presumed to have been properly executed, the effect is that a party claiming fraud, duress, or lack of capacity must demonstrate that one of these defeating conditions has actually occurred, and in the absence of such a demonstration, the court will accept the validity of the will, even though the party claiming that the will was validly executed has proved nothing at all. In the same way, the common law has traditionally had a presumption of legitimacy, such that a child is presumed to be the legitimate offspring of his parents, and the burden is on someone challenging legitimacy in the context of a dispute about inheritance, for example, to show that the presumed fact of legitimacy is not in reality so. And perhaps the most familiar presumption of all is res ipsa loquitur, the thing speaks for itself, the effect of which, for example, is to establish that a surgical patient does not need to prove negligence when he emerges from the surgery with a sponge or a surgical instrument in his abdomen, because negligence will be presumed from the very nature of the event. Quite often presumptions do not operate on the basis of a clean slate, but require a party to prove something, by virtue of which something else will be presumed. A good example is the long-standing rule in most jurisdictions that proof that a letter has been mailed will create a presumption that it has been received. The presumption of innocence may be unusual, therefore, because it is a background assumption of the legal system. But in the normal course of things, the legal system will require a party to prove A, and by virtue of a having been proved, B will be presumed. A beneficiary under an accidental death insurance policy may have to prove that the decedent died from something other than natural causes, but under what is called the presumption against suicide, it will ordinarily be presumed that if the claimant so proves, then accident rather than suicide will be presumed. Consequently, the burden is on the insurance company to come forward and prove suicide, failing which the death will be presumed to have been caused by an accident. It is common to distinguish between rebuttable and irrebuttable, sometimes called conclusive presumptions, and it is the former that are most closely aligned with the burden of proof. When a defendant is presumed innocent, when a sponge is presumed to have been left in a patient's abdomen by virtue of the negligence of the nurse or physician, when a child is presumed legitimate, and when a will is presumed to have been validly executed, it remains open to the other party to prove, by the burden of proof that has been assigned to it, that the state of affairs embodied in the presumption is not in reality so in this case. The existence of a presumption of validity for a will, for example, does not prevent another party from attempting to prove that the will was made under duress, or as a result of fraud, or by someone not in full possession of her mental faculties at the time of execution. And if it is so proved, then the presumption can be said to have been rebutted. In this respect, the presumption is in effect an allocation of the burden of coming forward, a specification of the burden of proof to be borne by the party who has the burden of coming forward, and a statement of the facts that will be understood as having existed if the party with the burden either does not come forward or comes forward, and does not meet his burden of proof. Irrebuttable presumptions are quite different. In structure, they are similar to rebuttable ones, because an irrebuttable presumption also specifies the state of affairs that the law will assume to exist even if it does not. But because the law does not allow the other side to challenge the conclusion of an irrebuttable presumption, it remains unconnected with procedural issues such as a burden of coming forward or a burden of proof. Indeed, there is little difference, except in the form of expression, between an irrebuttable presumption and what we would simply call a rule of law. The state of Florida, for example, has, like all other states, a law prohibiting the sale and distribution of illegal drugs, including cocaine. The law imposes a much higher penalty on those who are trafficking in drugs than on those who merely possess them, and then goes on to say that anyone possessing 28 grams or more of cocaine is irrebuttably presumed to be in the business of and guilty of trafficking illegal drugs. In other words, if you are found in possession of more than 28 grams of cocaine, you are presumed to be a cocaine dealer, whether you are or not. The burden of proof is not an issue, because the law simply does not permit you to try to rebut the presumption, even if it is totally false as to you. Such a presumption might seem unfair. And indeed, this kind of presumption seemed very unfair to the Supreme Court for a few years back in the 1970s. But as the Supreme Court came to realize upon further reflection, an irrebuttable presumption is little different from any other legal rule. Yes, the possessor of 28 grams of cocaine might not be a drug dealer, but the person who drives at 70 miles per hour in a 55 miles per hour zone might not be driving unsafely. And the insider who buys and then sells shares in her own company in a less than 6 months period may not be in possession of any inside information at all. But as we saw in Chapter 2, rules do their work precisely by cutting off access to their background justifications, and few are surprised that exceeding the speed limit while driving very safely is still an invitation to a traffic ticket. Once we see that rules have force, even when they produce results that would not be produced by direct application of the rationales or background justifications, we can see irrebuttable presumptions in their proper light. If Florida, in order to address the problem of cocaine selling the background justification, had simply prohibited possessing 28 grams or more of cocaine, the non-dealing possessor of more than 28 grams of cocaine would have no better an argument than the safe driver who is exceeding the speed limit. Just as we would say to the safe driver that he has broken the law, even if he is not within the class of people the law was designed to encompass, We can say the same thing to the non-dealing drug possessor. An irrebuttable presumption is thus just a different way of characterizing an omnipresent feature of all legal rules. And there is no reason to suppose that there is anything deeply wrong with that. The category of interest, therefore, is the category of rebuttable presumptions, for these are the ones that actually make a procedural difference. By allocating the burdens of proof and persuasion, and by specifying what we might think of as the factual default, rebuttable presumptions are essential elements in the structuring of litigation, not only serving substantive legal goals, but also attempting to ensure that scarce legal and judicial resources are not wasted by forcing parties to spend time and money proving what is usually, but not always, true. Most presumptions arise in the context of facts, but presumptions can be legal as well as factual. Consider the structure of American equal protection doctrine, for example. It is now well settled that state classifications based on race, religion, ethnicity, and national origin are presumptively unconstitutional and will be upheld only if the state demonstrates a compelling interest in using such a classification, and demonstrates as well that there is no less restrictive of equality alternative that it can use to achieve that interest. Here the question is one not of fact, but of law. But we are still talking about a presumption. The law is presumed unconstitutional, but the state may rebut that presumption by satisfying a heavy burden of justification. Conversely, when a statute draws a classification within this category of suspect classifications, it is presumed to be constitutionally permissible and will be invalidated only if the challenger meets its burden of proving that the classification is irrational. It turns out that this kind of presumption not only pervades constitutional law, but may usefully characterize much of the operation of American law generally. As we have seen in various places throughout this book, it is sometimes the case in American law that judges will set aside the literal or plainest indications of formal law in order to serve the law's purpose or in order to achieve larger goals of justice. This is a fair characterization of Riggs v. Palmer, Church of the Holy Trinity v. United States, and United States v. Kirby, for example, and it is a frequent occurrence on the American legal landscape. But it is also the case that the formal law often prevails, even when the outcomes it produces are somewhat unjust or in other ways somewhat suboptimal. That is how we might explain TVA v. Hill constitutional separation of powers cases like Immigration and Naturalization Service v. Chadha and Bosher v. Sinar. The large number of cases in which unworthy beneficiaries who were in some way responsible for the death of the testator were, unlike Elmer Palmer, allowed to inherit, and possibly even United States v. Locke. And perhaps the idea of a legal or normative presumption is the best way of at least partially reconciling these two seemingly opposed lines of cases and decisions. It may be, that is, that the best characterization of much of American law is that the formal side of law, what the rules or the precedents say, will be presumed to control. But the outcome indicated by the formal law will not be the final outcome of the case, if the party burdened by the formal outcome can prove or persuade the court that the result so indicated will be highly unjust, or in some other way, not simply wrong but very wrong. In adopting this approach to the effect of rules and precedents, American law has perhaps used the idea of a presumption as a way of reconciling the stability and predictability needs that are satisfied by a formal approach to law, while recognizing that formal law cannot always produce the right answer, and that sometimes a wrong answer will be so wrong that it would be irresponsible and reprehensible were the legal system unable to do anything about it. 12.3 Deference and the allocation of decision-making responsibility. In the same cluster of ideas in which we find burdens of proof and presumptions, we also find the idea of deference. Law, perhaps even more than other institutions, is very concerned with jurisdiction, in both the technical and the non-technical senses. In the technical sense, the law worries about whether, and when a court has the power to make a decision and enforce a judgment against certain individuals and other entitles. Questions about personal jurisdiction are about whether, for example, a court can hear and decide a case against an individual with few connections to the location of the court, or at times about whether a court can exercise power over people holding certain kinds of positions. And sometimes the jurisdictional question is not so much about who a court can reach as about what a court can adjudicate. Thus, the issue we refer to as subject matter jurisdiction is about whether a court can hear cases of this kind, as when, for example, a federal court must decide whether its authority to decide diversity of citizenship cases between citizens of different states includes the authority to decide a case between a citizen of a state and another state itself. But as noted briefly above, the concept of jurisdiction looms larger in law than we might suspect if we were to focus only on the procedural questions of personal and subject matter jurisdiction. In this larger sense, jurisdiction is about who gets to decide what, and a pervasive concern of the legal mind is the question of whether some institution that made a decision had the authority to make it. It is not enough, especially for the law, that the decision was right. It must also be the case that the judge or other person making the decision, or the institution making the decision, was authorized by the system to make it. Whether it is constitutional concerns of federalism, or the question of when congressional legislation has preempted the states, or whether it is for a judge or a jury to decide questions of fact, most legal decisions involve, sometimes explicitly, but usually implicitly, the question not only of whether some decision was right, but of whether the right institution made it. Many of these issues arise in the context of direct determinations of jurisdiction or decision-making authority. But sometimes they are embedded in the important question of deference. Under what circumstances will a decision-maker respect the decisions of another body, even when the decision-maker thinks the decision of the other body is mistaken? In some respects, this resembles the questions of authority we took up in Chapter 4, but deference often operates in just the opposite direction. When we think of authority, we ordinarily think of it as a relationship from top to bottom. Those in authority, sergeants, parents, teachers, supreme courts, give orders or make decisions, and those below them are expected to obey, even when they disagree with the decisions. To respect authority is to look up from the bottom to the top. Deference also involves respecting decisions with which the deferrer may well disagree. But by contrast, often it is from top to bottom, rather than from bottom to top. Deference is the way in which those in the higher position in some hierarchy allow some leeway to those below them in the service of efficiency, respect, specialization, diversity, or separation of powers in the broad sense. Thus, it is frequently the case that an appellate court will defer to the determinations of a trial judge, and in doing so it says that even though it exists above the trial judge in the hierarchy, it will accept some number of trial decisions as valid, even if it disagrees with them. So too when a judge defers to the jury, when the Supreme Court defers to Congress or an administrative agency, or when the European Court of Human Rights allows individual states a margin of appreciation in making their own individual rights determinations. Deference is in important ways closely related to presumptions and burden of proof, and often the mediating idea is the idea of the standard of review. When an appellate court reviews the decision of a court below, or when a court reviews the actions of an administrative agency, it typically operates according to an explicit standard of review, which in a way is the mirror image of a burden of proof. It is often the case, for example, that a court will not overturn the action of an administrative agency unless it finds the action to be arbitrary and capricious, and an appellate court will not generally overturn a trial court ruling with respect to the admission or exclusion of evidence unless it finds that there has been an abuse of discretion. Such standards are highly deferential, because their implication is that most evidentiary and administrative decisions will remain standing, even by judges who disagree with them, unless the decisions are, say, outrageously or extremely wrong. Decisions that are perceived from above to be only somewhat wrong, or maybe even significantly wrong, will under these highly deferential standards be allowed to stand. Similar standards apply to the review of jury verdicts, to appellate review of trial court findings of fact, and to myriad other questions. But at other times the standards of review are not nearly so deferential. When an appellate court reviews a finding de novo, from the beginning the idea is that the appellate court will not defer to the court or agency below, but will make its own decision. And this is frequently the standard explicitly or implicitly applied to review of questions of law. When an appellate court is reviewing a trial court ruling about the interpretation of a statute, for example, it will typically say or assume that its ability to interpret the law is no less than that of a trial court. There are no witnesses to observe or physical evidence to evaluate, and thus the standard reasons for appellate deference to trial decisions apart from simple efficiency are no longer present. And under such circumstances, appellate courts become less hesitant to substitute their judicial judgment for that of another judge. So too, traditionally, for review of legal determinations by an administrative agency, where the presumed greater expertise of the agency entitles it to deference as to questions of fact and policy, but not for questions of statutory interpretation. Deference, legal presumptions, and the burden of proof are thus concepts that not only work together, but that are also in some respects, and in some contexts, different ways of saying the same thing from varying standpoints. It may be hard to understand the idea that a defendant in a criminal case is entitled to deference, and thus there may not be a corollary in the criminal law context to the fact that the prosecution bears the burden of proof. In other contexts, however, the relationship among the burden of proof, deference, and the standard of review is more apparent. It seems quite sensible, therefore, to say that because an administrative agency is presumed to have come to the correct conclusion within its domain of expertise, then it is entitled to deference, and thus that its decision may be overturned only if the challenger can meet the burden of proving that the agency decision was, say, arbitrary and capricious. There is only one relationship in the previous sentence, but deference, presumption, the burden of proof, and the standard of review are all different ways of describing that same relationship from different angles. The relationships and concepts described in this chapter not only relate to each other, but also connect to the larger themes in this book. When a court defers to a lower court or to an agency, or when it operates under a high standard of review, it in effect commits itself to accepting, maybe tolerating is the better word, some number of what it perceives as erroneous outcomes. So too with presumptions, which under conditions of uncertainty will sometimes compel factual conclusions that are simply not true. And when a party finds itself saddled with the burden of proof, it will on occasion not be able to prove something that is in fact the case. Just as the beyond the reasonable doubt standard in criminal law will acquit some number of people who are probably guilty, so too will any high burden of proof commit the system in which it operates to some number of mistakes, although it is to be hoped that they are, like the mistake of acquitting the guilty, mistakes of the right kind. In accepting the inevitability and strategic or long-term desirability of some number of mistakes of mostly the right kind, the legal system's use of burdens of proof, presumptions, standards of review, and principles of deference, perhaps especially the last, resembles the system's use of rules and precedents, and resembles the legal system's at least partial commitment to formality. It may also resemble the legal system's willingness to make decisions on the basis of less than all of the best or available information. In all of these dimensions, the law, more than many other decision-making institutions, commits itself to accepting wrong, or at least suboptimal answers, and it does so in the service of larger or longer-term institutional values, as well as service to the idea that the best way to get the largest number of correct decisions in the long term is often something other than attempting to make the best decision on every occasion. In operating in this way, law and legal reasoning may not be different in kind from other decision-making institutions, but they may differ in degree. At the heart of much of law's use of its characteristic reasoning devices is its acceptance of the fact that the best decision is not always the best legal decision. In operating in this fashion, law does not intend to be perverse. It does, however, intend to take institutional values especially seriously, and it does that in the hope that in the long run, we may be better off with the right institutions than we are when everyone simply tries to make the best decision.